Diane Rondini and Eileen Hirsch are here today to talk to us. Diane recently retired after working as a staff attorney representing juveniles and as a practice coordinator. And I think her last position was legal counsel for the Wisconsin State Public Defender's Office. She is the co-director of the Midwest Juvenile Defender Center and is on the advisory board of the National Juvenile Defender Center. Diane has served as an adjunct instructor at Bryant and Stratton College and Marquette University, is a certified juvenile training immersion program trainer, and helps train new attorneys in juvenile law throughout Wisconsin. She was one of the creators and a program leader for the Student Expulsion Prevention Project. She currently acts as a consultant for the Juvenile Rural Access to Training and Expertise Grant. Eileen Hirsch retired in 2016 from a 30-year career with the Wisconsin State Public Defender's Office. She worked as a trial attorney and administrator before she became an appellate attorney, handling a mixed caseload of juvenile and criminal appeals from all parts of Wisconsin. Two of her most important Wisconsin Supreme Court cases required in-person juvenile interrogations to be recorded, which is a very big breakthrough case, and held that juvenile offender registration was discretionary, not mandatory, in juvenile delinquency cases. Post-retirement, she became director of the Juvenile Life Without Parole Project at the University of Wisconsin Law School's Remington Center. Her second retirement was in 2018, and she is now a member of the board of directors of the National Juvenile Defender Center and National Youth Law Center. For her work on juvenile justice, she has received the Livingston Hall Award from the American Bar Association and the Kutak Dodds Prize from the National Legal Aid and Defender Association. So thank you to Diane and Eileen for coming today to talk about their latest project. Go ahead.
I'm going to start out and then I'll turn it over to Eileen. So you just heard a little bit about us, and you heard now what two retired public defenders do in their spare time. Right. Right. So what I wanted to tell you is that, and what you heard, we both pretty much devoted our legal careers to youth justice projects. And this is one of them. It's just the two of us, just two people who think that this is a really important issue that we hope that our state will address. One of the things that Craig told you is that we were both part of the National Juvenile Defender Center. That is an organization that provides technical assistance to youth defenders throughout the country. I currently serve on their national advisory board, and Eileen did for many years before me. One of the things that the National Juvenile Defender does is they have a summit. They sponsor a summit every year for youth defenders to attend from all around the country, and they present on really compelling juvenile cutting edge issues. And Eileen and I were both there the year, feels like many years ago now, where they presented, juvenile shackling is something that they present on fairly regularly, but the year that really I wanted to tell you about was the year that Carlos Martinez presented. He is the elected public defender in the Miami-Dade 11th 11th Circuit. And he was talking to us and presenting to us about how he was able to change the law in his jurisdiction to abolish indiscriminate shackling of juveniles. And it took him a while, and it seems like it's going to take us that long too. But something that he told us was, and I get, so just a step back, one of the other things that the National Juvenile Defender Center does is state assessments, which assesses each state in a variety of areas, but specifically in access to counsel. And as part of that assessment in Florida, he participated in monitoring court hearings in his county. And one of the things that he saw in 2006 that shocked him and led his call of action was an 11-year-old girl who was 3'6" tall. She was shackled with handcuffs and a belly chain, and that connected both the handcuffs and the leg irons, and she was led into juvenile court in Tallahassee's Leon County Courthouse. And that was a turning point for him. And when we heard his story, that became a turning point for us. He fought to end this practice, both administratively on a case-by-case basis. And this dates back to 2006. The public defender's office worked on filing motions on a case-by-case basis to have kids not be shackled when they were brought into the courtroom. He later, and the court finally actually agreed and granted those motions, but later in 2009, they were able to, with his help, create a statewide judicial rule that was adopted against indiscriminate shackling of juveniles. And his quote, and I'm very proud to say this, is that 10 years later, more than 30,000 unshackled children have gone to court in Miami, and none have successfully escaped or injured anyone in the courtroom. So this has had a huge impact on us. And so even in our retirement, we felt that this was an important issue that we were passionate about and we wanted to work on. And honestly, we have both worked on this issue on a case-by-case basis and policy ways for several years. We would bring our own motions. The public defender's office has done some trainings on this and provided sample briefs and motions. The children and the law section of the state bar, when I was the president of that section, we were able to get with Elena Faley, who is on our call, the Board of Governors to adopt a state bar position against indiscriminate shackling of juveniles. So that's what it's all about for us. That's why we put our time in our retirement into this. So really today, what the purpose of what we want to put forward to you is that we wanted to first communicate this with you. And honestly, the first thing we probably needed to let everybody know is that this is actually happening to our children in the state of Wisconsin, in different counties in different ways. I think a lot of people, because juvenile courts are closed or most often closed, are unaware that this is happening to that same 11-year-old that I described here in Wisconsin. We also wanted to let you know about the proposed rule change because it can really affect all 72 counties in the state. And then we want to answer any questions or hear your thoughts, ideas, and comments on the rule petition. The second thing that we want to ask you is to champion this cause with us. We want you to, persuade you to support this rule. I see I may be preaching to the choir here, but I still would ask that you take this back to your organizations and ask them to support this and consider when the Supreme Court circulates this petition for comment that you are willing and, with our help, if you need it, to submit a letter of support or even come to testify if you so choose. Also consider reaching out to your judges and in your jurisdictions to let them know about this. So neither of us have actually done this before. So it's been quite a learning process for us, but what this situation is unlike a traditional case that appears before the Wisconsin Supreme Court for argument. In a situation like this, we've been told that you can actually reach out and communicate with the Supreme Court justices on this issue to the extent that they feel comfortable. So, if you have that connection or you feel comfortable and want to discuss that with one of the justices, it is our understanding that you are free to do so. Finally, we are asking for your collaboration on this issue. We want to, we really hope and feel confident in our work and feel confident that the Supreme Court will look at this, and we hope to have this rule put in place. But even if it fails, we want people to know about this, and we want people to go back to their jurisdictions and work on establishing a policy. Even if we can't get a statewide policy, it can be done on a case by or county by county basis. So we would ask for your help with that also. So the first thing that I want to show you, and by the way, all of these documents can be found on the Wisconsin Supreme Court website. And you can, we're going to show you two of them just because of time, but the first screen share that we want to show you is the proposed rule, and just go through it. So in a nutshell, this is based on a model rule that a national model rule that is has been drafted by the Campaign Against Indiscriminate Shackling, and is part of you can find this on the National Juvenile Defender Center's website. This is the rule that, well, not this particular rule, but 33 states and the District of Columbia have adopted rule positions, I guess I will say, against indiscriminate shackling, whether it be by Supreme Court rule, legislation, or case law, and some maybe even both. But 14 of the states have done it through Supreme Court rule. So what we believed, we took this model rule and we determined, I mean, Eileen did most of this work, I'm going to say, so I will jump in whenever you feel like, but we felt it was the most appropriate to add to Wisconsin statute sections 48,299 and 938, 299. And the reason that we felt that way is because even though chapter 48 is the children's code and about, dependent and generally abused and neglected children, that statute still allows for kids to be detained in certain circumstances. And so those kids could still be subject to shackling. And then, of course, chapter 938, which is the juvenile justice code, addresses all children in Wisconsin or youth in Wisconsin that are facing any kind of delinquency charges. So the first part of this rule is just basically a description of what it means to be shackled or restrained. And I think that that's fairly self-explanatory. It's really any kind of means of restraint. And what we have mostly seen in Wisconsin is handcuffs, leg irons, belly chains. When I practiced in Milwaukee, this was, so I haven't been there for a while. And of course they have a rule now against this, but they used to basically have a leg cuff, and they would shackle the child to the floor when they came into the courtroom. Mm-hmm. This would cover any kind of restraint. And then it goes further to say that there's a presumption against shackling unless the court finds that it is necessary to prevent harm to the child or another, or the child has a history of disruptive behavior in the courtroom, or there's a risk of harm to others. And this is, I think, really a key piece, by recent behavior or a substantial risk of flight, and that there's no less restrictive alternatives. This also allows for a hearing, and I've done those hearings. They're short. They're often done with the child out of the courtroom. And I've done that when I've practiced in Dane County. And if after hearing every stakeholder, if you will, the court decides to shackle, they still need to allow for limited movement. And again, like I said, they can't be restrained to the wall, the floor, or the furniture. And they have to be able to have their hands free and be able to the extent that they can, it helps them sign documents, communicate with their attorney, understand the court proceeding. And so that's really basically the nutshell of the model rule. What we added in Wisconsin was oftentimes these hearings are done without the child present. And we added a section under 938.299 sub 5 where it allows for video conferencing or telephonic conferencing for the child to be in the courtroom for the shackling hearing. I don't know how often that would be implemented or used, but it's there in case a child wants to be present in some way, shape, or form for the hearing. I think it's important for you to know that this does not abolish juvenile shackling, but it creates that presumption and allows for the hearing. And if it comes to that, everyone is able to give input to the court on the shackling status before the court makes a decision. So how did we accomplish this? This would be our next share.
Can I let me just add a little point here, just to make sure. So we figured out that we could bring this rule. There's a statute. It's and it's in the petition, and Gretchen's put up the site for the petition, but it's on the Wisconsin. I always just look up Wisconsin Supreme Court rules petitions, and you can find it there. And our petition, our memo in support, and 4 appendices are on that, and this is one of the appendices you're looking at now. But it allows the Supreme Court to pass rules then that actually become part of statute. It's not used very frequently, but it is used sometimes. Diane's pointing out it's 751.12 is the statute. And the process then is we file it, and then the Supreme Court, when it gets around to it, sets a public hearing on it and sends out a request for comments. And so one of the things we're hoping, if you support this and you and your organization support it, would be that you would write to the Supreme Court and tell them in their request for comments why you think this is a good rule. If you do, you can also appear at the hearing, but the comment section is actually very helpful. And then if the Supreme Court adopts the rule, it then shows up right in the statutes at 48.299 and 938.299. So that was the outline of how we decided to go about this. So,
right.
Okay.
Yes.
And then we'll pick up on this.
And I guess just for you legal folks out there, this isn't something that we are asking them to do that is something new or novel. There is, and Eileen will get into this much more, but there is case law, a case specific case, State versus Grinder, which she will tell you about, that says that the courts have control over the decorum of the courtroom, but also recently meaning 2012, the Supreme Court did something similar in adopting Supreme Court Rule 6804. So this isn't, I don't think that it's, I think it's rare, but I don't think that it's first impression.
It's not
for
novel.
the court. Right. Right.
It's not novel.
Right. So
go ahead and
okay, I'm going to talk about I'm going to talk about this document and how it was created. And then if you want to look at a specific county, we can scroll through that. But so this is more just some background on how this was accomplished. So as I said, we've been working on this and with others for a few years. And one of the people in the public defender's office, an attorney there named Eileen Fredericks, conducted a survey in 2017 on what was going on in each of the 72 counties as it relates to shackling. And I had an intern in 2020, and I will say that that is what Eileen based much of her training and presentations on, was that data. We did some follow-up data with an intern in 2020. And so that is where this data that you're seeing now came from. And then because we were writing this and, we checked and double checked, we got input from others that confirmed or changed some of the things that, we were found in the notes, but we believe that this is accurate as of the time of filing, that the survey of the status of juvenile shackling in each county in the state of Wisconsin. So as I said, we tinkered with the model rule a bit to make it Wisconsin specific. We ran it past the Legislative Reference Bureau because we are really not drafters of this sort of thing generally. They gave us some input. We talked to stakeholders, particularly the judges in each of the counties that have eliminated indiscriminate shackling. And I'm going to talk with you about that now, in a minute. But we also contacted the other Midwest states, specifically Illinois, regarding how it's working in that jurisdiction. Since we've been working on this, Michigan has approved a Supreme Court rule against indiscriminate shackling, and Minnesota just approved a statute against indiscriminate shackling, both within the last couple of months. So what we're really proud to say is that there are 5 counties in Wisconsin that have abolished and have actual rules in place against the indiscriminate shackling of juveniles. And those are Milwaukee, La Crosse, Dane, Marathon, and Eau Claire. And of those 5 counties, we're really, really proud and happy to say that we have judges as co-petitioners from each one of those counties. So we have Judge Crivello from Milwaukee, Judge Gonzalez from La Crosse, Judge Mitchell from Dane County, Judge O'Neill from Marathon County, and Judge Schumacher from Eau Claire as co-petitioners in this. We've also been continuing to seek out input from others. We've met with the chief judges, we've talked to the sheriffs, the DAs, the intake workers, detention staff. Some of that information that we received and their comments are part of the petition. Some of it, the organizations are still taking up and discussing. Eileen put together the legal memo in support, and she provided not only the legal authority for the Wisconsin Supreme Court to make this rule, which we talked a little bit about before, but also she put together the evidence-based reasons why this practice is harmful to Wisconsin's children, the juvenile court process, and the community. Now I'm going to turn it over to Eileen now, and I'm not sure the best way if people have questions on the 72 county analysis that they'd like to ask before we move on, or do you want to wait and do that after Eileen talks?
I can,
yeah.
Let me just, I'll give you a little summary of this.
Yeah.
And just give me a minute to start. So the building blocks of this memo in support, and I really do think of it as blocks, is that first of all, the court has authority to do this. And it's really based on this case, State versus Grinder, which was in a case involving an adult criminal defendant who was shackled during a trial. And the Supreme Court said that the trial judge had erred by relying on a sheriff department policy to determine whether he would be shackled or not. And it said that the court has to make a case-by-case decision whether shackling is necessary to maintain order, decorum, and safety in the courtroom. So that was actually, knowing that case is what got me thinking that a judicial rule made sense here. And then there's a long history, and I won't go through all of it, but there's this old 1909 case called Milwaukee County versus Stevenson, or vice versa, where the Supreme Court held that Milwaukee County judge had the authority to hire a bailiff in order to have security in the courtroom, even though the county didn't like that because of its effect on the budget. And then as we pointed out, there's a 2012 rule in which they again specifically said that courtroom security is up to the judge, that the judge has to make a decision on a case-by-case basis. So one of our arguments is that this is clearly within the Supreme Court's authority and the judicial authority, and that it goes to the core of their authority, which is maintaining the safety and decorum of the courtroom. And that so that's one of our arguments, is that that's really, this is a judicial matter that should be determined. We also, there's another bill that we had to put that in because that will be an issue. The first building block is evidence that this is dangerous that this is harmful to children. I'm not going to go into that. I think there is absolutely no disagreement anywhere in this country that shackling is good for kids going into court. And all of the evidence I can find is that it is harmful to children. The interesting thing is when I began reading cases about that, the harm to children, there are a number of state Supreme Courts, only 5 or 6, that have considered whether they have a constitutional right not to be shackled in non-jury proceedings. Illinois actually was one of the first ones in 1977. And they looked at the reasons about the shackling, not shackling people during jury trials, which were that it interferes with the right to counsel, it interferes with the presumption of innocence, and it is contrary to the order and decorum of the courtroom. And they said, certainly the interference with the right to counsel and the decorum of the courtroom apply in juvenile court. They also found that it actually works against the interest of the juvenile court, which is to rehabilitate children in a couple of ways. One is if a child decides that they're being treated like a dangerous criminal, that can form part of their identity, and then they become more dangerous. They act according to how they're identified by adults. The other possibility is that they won't feel treated fairly, and that people actually who don't feel like they were treated unfairly have a higher rate of recidivism than people who do. So interesting twist on this is it's not just about the children, it's about the mission of the juvenile court. And I think that's really important, and it makes common sense too. I mean, I always think about this, if a child's brought into court, put in front of the judge at one of those early hearings, and then the judge explains the presumption of innocence, it seems like a pretty mixed message, to say the least. You're innocent until proven guilty, but we're shackling you just because you're dangerous. So those factors came into it. And then I went to this chart and pointed out, this chart is, I know it's small on the screen, and believe me, I've spent hours poring over it, but basically there's about 25 counties in the state, many of them pretty substantial counties like Fond du Lac, Washington County, Appleton area that's Outagamie County, Wood County, Rock County. There's about 25 counties where they are indiscriminately shackling kids. So that's a lot of kids. There's about 8 counties, which interestingly enough, some of them don't shackle very many kids and some do, but they leave it up to the sheriff, which is exactly what the court said you weren't supposed to do in State versus Grinder. And Kenosha County is one of those counties, from what we can tell, that the sheriff doesn't really shackle a lot of kids, but it's a sheriff decision as opposed to a court decision. And then we have a fair number, Wisconsin has a lot of small counties, a fair number that said, we don't see many of these, but generally when we do, they're not shackled. So these are kids who are always coming from secure detention to court. And then of course, we found these 5 large counties, including Milwaukee, who said, we don't shackle kids at all, and we have a policy against it. We don't shackle kids much, and we have a policy against it. And so our basic argument using this chart is that the Supreme Court needs to give guidance to county judges around the state about when and where kids should be shackled. And that our proposal, with a presumption against it and a court decision based on the safety and security of the courtroom, is consistent with the standard in Grinder. So that's the essence of our legal argument. I mean, what was wonderful and really fun for us is we interviewed judges and social workers and sheriff's deputies and secure detention directors in these 5 counties. And there's just a lovely section of the memo. It starts at page 8 of the memo, describing our interviews. And they really positive comments from everybody involved in Dane, Eau Claire, La Crosse, Milwaukee, and what was the other one? Marathon counties. Everybody really is saying it works great. It works well. They're not having any problems. Their hearings are short when they have a question. I think La Crosse has put 2 kids in shackles for the 5 years they've had that policy. Numbers are similar for Eau Claire. It's had a policy since 2016. I think Milwaukee was an important part of this. And because they just actually enacted this policy about the time that COVID started in February of 2020. But we think they had been informally doing it a little bit before that, and now they're doing it again. And Judge Crivello just turned out to be a very strong supporter of this, as much as this kind of policy, as is Sheriff Lucas and the director of the Secure Detention Center in Milwaukee. So if you're talking with people about this, I think one of the most important things is that we have a fair amount of experience in Wisconsin with this kind of policy, and that it's working well. And it's working well in counties where everybody thinks the worst crime is, which is, of course, Milwaukee and Dane, probably. We also point out, we have data, as Diane mentioned, if you go to, and it's in the brief, the Campaign Against Indiscriminate Juvenile Shackling. They have national information, from places around the country that have enacted this kind of rule. And again, all excellent experience, very, very few problems with this rule. And then there's just a little section of the memo that talks about all the different organizations that support this kind of rule, including the American Bar Association, the Wisconsin Bar Association, and the the National Council of Juvenile and Family Court Judges, which has been a supporter of this for quite a while and a leader in the area. So that's where we are. I think we've described it and sort of given you a little outline of our arguments. I'm curious if you have questions for us.
So if anybody has a question, please put it in the chat. Gretchen has one, so I'm going to hand it off to her first, but please put your name in the chat if you've got a question, or just use the raise hand function in Zoom. And please turn your screen back on so we can chat. Thanks.
A lot of your memo is based on social science. Our Wisconsin Supreme Court has said social science has no place in the courtroom. So how will you convince our Wisconsin Supreme Court that this is a legitimate issue for it to take up?
So I actually don't think that this is based on social science. I mean, I actually believe there is some social science saying there's harm to children, but there's a lot of case law on this. I mean, a lot of this argument is based on what the US Supreme Court and the Wisconsin Supreme Court have said about shackling in the courtroom. And in fact, there's this US Supreme Court case, Deck versus Missouri, that cites some old cases talking about how shackling is humiliating. And when applied to adults, which it is most frequently in these cases, they talk about it being humiliating and that it should be minimized as much as possible. That the only reason to shackle in a juvenile in a courtroom is for the safety and security of the courtroom. And so I think that that we're pretty well based in law. I also think that our strongest arguments really are how easily this works and what a good process this is, that based on the experience of the 5 Wisconsin counties. And in those counties, some of our interviews, they say that kids actually act better in court and in secure detention when they're not shackled, that they behave better, they participate more in the court, they work better with counsel. That's not social science, that's actual experience in a number of Wisconsin counties and around the country. So I would say our argument is based mostly on law and actual experience in Wisconsin courts. There's a little bit of social science on it, but if you look at some of that social science is based on brain development. I think we've all heard about that. The US Supreme Court in 2005 in Roper versus Simmons recognized that juveniles' brains are different than adults and talked about those differences. So even that about the brain development is in the legal lexicon for us to draw on. I would say the other thing, we mentioned this, I didn't really mention it today, but we do say that part of why it's even harder for kids who have been exposed to trauma. There's a national study that shows 70 to 90% of kids in juvenile court have been exposed to serious adverse childhood experiences, the ACE factors, which are traumas really. And that trauma, I mean, that is pretty clearly established. The Marathon County plan actually came out of their trauma-informed care committee. And our courts have really educated and pushed and talked. And I think that the Supreme Court generally is on board with understanding trauma and how what you do in the courtroom can affect a traumatized child. So I think we're going to be okay. I would argue law, I would argue the hard science of looking at brains, and I would argue actual experience. And I think they're going to understand the issue of trauma. You could call that social science, but I think that's pretty well ingrained in our court system. What do you think, Gretchen? Is that a good answer?
Yes, but I have another question, if I can. This one's easy. This
Okay.
one's easier. I notice in a lot of these, in a lot of counties, it's at request, they might unshackle. So are you reaching out to WACDL, guardians ad litem, public defender's office to tell them to request to unshackle?
You want to take that?
Well, the public defender's office has been working on this for a long time. They've been, there's been, presentations statewide. There's been different counties that have taken this on and have, we've worked with getting a motion together for them. So we remind people basically every chance we get to ask for the shackles to be removed. Something that you heard about me is that I'm now consulting on a J-rate grant, and that is one of the things that we will be talking about in every single public defender region is, the first thing to do at a detention hearing is ask that the shackles be removed from the client. So there's been some judicial trainings on this. There's, the district, everybody's very aware of this issue, and sometimes it works and sometimes it doesn't. And sometimes there's a good reason that a child remains shackled, and sometimes it's not the good reason, which is that's how we've always done it. And so we're hoping that this change will we certainly are not interested in micromanaging each county and how they implement this, just providing guidance on best practices and model rule to implement the presumption against indiscriminate shackling.
Thank you.
All right, in the chat, we have Devin Martin saying that the State Bar of Wisconsin supports this petition, and a policy position was adopted in 2020, and a link to that is included if anyone wants to see it. So go to the chat to look for that. And then Shonda Hayes, can you unmute and ask your questions? It looks like she has two.
Hello. I was just curious if these policies also cover our youth, like for example, 17-year-olds who are charged as adults.
Yeah, I think we missed a little bit of your question, but I think you're asking if the rule would apply to 17-year-olds who are charged as adults.
Yes.
And no, the answer is that what we are asking for in this petition is kids who are in juvenile court.
Okay.
And really, just because there's a couple things that are left out of this petition. One is kids who are in adult court, but we just don't think that we can go into that. It gets more complicated at that point. And the other thing I just want to point out, if you hear any of this from people, any of this criticism, is this does not apply to the transportation from the jail or the secure detention center to the courtroom. We think that's the sheriff's authority and that we can't really regulate that with the judicial rule, but that once they open the courtroom door, that becomes the judge's authority. So we do have those two limitations in our request.
Okay, thank you. And I was just curious if you had like a script written that we could utilize so that we could send it to our judges and DAs in our counties. I'm from Racine County, and I see on the map that, or on your list, that it states that they still handcuff the youth. So I would like to bring awareness to our judges and the DA. Is there a script that you guys might have written?
Oh, the motion, I think.
Well, yeah, we did have a, whatever, it was a 1-pager that maybe turned into a 4-pager that we could probably send you. Sure. But it's actually probably best at this point to just refer them to the memo, right?
Yeah, or I would suggest, I think our best, the public defender has a motion and a memo in support. And you could get that from us or Eileen Fredericks at the public defender's office if you're not on staff. But if I were doing it, I'd probably at this point, I'd write a motion and I would I'd go through the little memo and support that's posted on the Supreme Court website and use as much of that as you like in support of your motion.
Okay, thank you. How would I get a hold of you guys then?
So can we do this through you, Gretchen and Margot? How would you get a hold of our memo?
Yes, and
That's
that way
on
I can add to it.
You could go to the Wisconsin State Supreme Court, which I just put in a search for Wisconsin Supreme Court rules. And then if you look at that page, there are pending petitions, no hearing scheduled yet. And one of them is juvenile shackling, and you can pull up all those documents. There's like 5 documents there that you can pull up and get it, the whole thing. Thanks.
Dorothy, you have a question?
Yeah, there's some pretty horrible stories from other states about using shackles on kids. And I just wondered if you have any examples of how kids with disabilities are treated. Are they in a county that does shackling? Do they do that with kids with disabilities? Are kids with disabilities more likely to be shackled? That sort of thing.
Seeing that background of you.
I mean, I don't know. I think we just have anecdotal information on that.
That's
and
fine.
If it's a county that everybody's shackled all the time, then yes, those kids would be being shackled also. And, as Eileen indicated, a very high percentage of the kids that travel through the juvenile justice system have special needs in some way, shape, or form, whatever they may be. So yeah, they are probably the ones that would likely be the most traumatized or the most affected by something like this. What I can just tell you what I see or what I saw. And a lot of times and how this is, it's negative for the child, no doubt. It can just physically hurt them, being shackled. But they come into the courtroom and their parents see them and it's horrible. Oftentimes parents start to cry. The child starts to cry, very worked up about what is. I don't want to say stop paying attention, but kind of stop paying attention to what's actually going on there because they're so upset by, by seeing their children in shackles, and then the child is in turn upset.
We should talk about this. I think that there's in the memo, there's a couple of comments by state public defender attorneys about the effect on their clients, and they're just talking generally. But I think that's something that we can ask the state public defender to do, is give us more specific examples of these things. I've certainly appeared in court with, I remember very clearly appearing in court with a 13-year-old who wasn't even competent to understand court proceedings. There was a level of, he had disabilities, he had reading disabilities, speaking disabilities, and there was a psychological evaluation that said he just didn't understand what was going on in court. but there he was, fully shackled in court. So
We also, in the survey, you can look at it. There's a few instances where the public defenders have commented that the Chapter 51 kids
Yes.
are shackled also.
Okay,
Yeah.
So
okay,
Can you
thank you.
explain Chapter 51 for folks who don't know what that is?
So Chapter 51 is basically a mental health commitment. Somebody who's, it's, you know, that they have a mental illness and that they are, I mean, this is a generalization, but that it has to be a mental illness that they have been found to be in danger of harming themselves or others. And they're coming to court from a psychiatric placement of some kind is basically, and the question is whether they should be involuntarily committed to a psychiatric placement. I think that one just kills me, that how many of these counties said that the Chapter 51 kids are shackled. I think a lot of them are coming from Winnebago or Mendota or something. But, you know, we have our fair share of suicidal girls coming to court under Chapter 51 proceedings. And I just cannot imagine what that does to a child who is already struggling with self-image and mental health issues.
If anyone else has a question, please either raise your hand in Zoom or else just put your name in the chat. And meanwhile, Diane and Eileen, if you could just say just let people know about how they can find out when that comment period opens up. I know the Supreme Court sends out like a memo or a notice saying it's open, but how do attendees today find out about when that comment period opens?
You know, we just keep checking the website. And I'm assuming as petitioners will be notified, but we check the website frequently, to find out if a date is going to be set.
So let me just say this, I assume that the Wisconsin Justice Initiative has many of the attendees on file. We'll certainly let you know, and then you can send it out to other people. I know we have Dorothy Dean's email address, so we're going to send that out to a lot of other organizations and people when we get it. And maybe you can help by spreading it out from there.
Any other questions for Eileen and Diane?
Just if you could give the name of the case again that said
Sure.
shackling should not be assumed.
Yes. Let me see. It's Grinder versus State, GRINDER. The site, it's at 190 West 2nd. I don't have my first page, but it's 190 West 2nd, and the quote I have is at page 552.
Okay, thank you.
But you should be able to find it from that. I want to thank you all for spending an hour with us and learning about this. I really appreciate your attention and the fact that you stayed for the whole hour.
Thank you.
Thank you very much.
And to those of you on the screen, I see you that have helped us with this. Thank you for that too.
Thank you very much.
I do want to thank Diane and Eileen and for their time today. It's just they're all the work that they've put into it is amazing, and they're so passionate about it, and it's just really informative to me about what they're doing. I want to thank all of you for joining us, and we hope you stay safe until we see you again, whether by Zoom or in person. We'll have our next salon probably mid-November, most likely on a Wednesday as usual. So the speakers yet to be announced, but look for notices about that. And I will leave the Zoom meeting running for a few minutes if anyone wants to stay and chat, but otherwise, please have a nice afternoon.